Hello everyone, my name is Gursain Singh and here are my group members Jashanpreet Kaur, Mandeep Singh, Pradeep Kaur, Eknur Singh and Manroj Singh. Today we are going to present our presentation on Bank of Montreal versus Duguid 2000 case. Here are the content of this case. First of all, we are talking about its introduction, facts, then issues, holding, rationale, and at the end we are talking about Q&A section. Now, I am going to give a quick overview of this case. The case is an important ruling in Canadian contract and loan law, as it makes a handy precedent for financial responsibility under fraud conditions. It is whether a customer would be held liable for unauthorized transactions in their bank account. The decision affects banks' management of fraudulent transactions, establishing benchmarks by which financial institutions have to operate in a way that forestalls unauthorized transactions without denying consumer rights. Now, Ek we're going to tell the facts of this case.
Hi, I'm Iknur and I'm here to tell you about facts. For the factual background, Plaintiff Bank of Montreal, Canada's largest bank seeking to recover funds lost on account of unauthorized transactions, defended Duguid, one customer whose account was used in illegal transaction. Important facts. Duguid and bank account is said to have been used in illegal transactions. BMO argued that Duguid should held liable for the payments of financial losses incurred due to the transaction. The case went to resolve whether BMO had the legal basis to hold Duguid accountable for losing the money or not. So here are some procedural history. Trial level Ontario Superior Court of Justice. The Bank of Montreal initiated legal proceeding against Duguid, recording a financial dispute. The central issue revolved around whether the BMO had a legal right to enforce a security interest against Duguid and whether Duguid had a valid defense against the bank's claim. The trial judge examined the contractual and statutory framework governing the financial transaction and security arrangements in question. Appeal Ontario Court of Appeal. The case was brought before the Ontario Court of Appeal, which reviewed the trial court decision. The appeal court considered key legal arguments including the interpretation and application of security interest, banking laws, and the enforcement of financial obligations. The Court of Appeal ultimately rendered a decision in 2000, which was reported as 2047 OR 3rd 737 CA. No further appeal to Supreme Court of Canada. There is no record of an appeal to Supreme Court of Canada, which means the Ontario Court of Appeal decision, which was the final word of legal issue presented in the case. Initial legal action, Ontario Superior Court of Justice. The Bank of Montreal filed a lawsuit against Duguid to recover funds based on a financial transaction that involved a security interest. Duguid challenged the claim, arguing that the signature was forged and that he is a victim of a fraud. The trial ruled matter determined whether the bank had a valid security interest and whether Duguid was liable for a debt or not.
There are several issues in a Bank of Montreal versus Duguid case. The first issue is that the court had to determine if Duguid could be held responsible for transactions made from his account without his authorization. The main legal question was whether BMO had enough evidence to show that Duguid was liable for the fraudulent charges, either through negligence or direct responsibility. Another issue is that Duguid argued that he should not be liable for the debt claimed by BMO because his signature on the loan documents was allegedly forged. The court needed to decide if he could escape the liability due to the forgery and whether he had taken sufficient steps to prevent such fraudulent activity. The another main issue in this case was that Duguid's negligence played a role in the fraud. The court examined if he had been careless in monitoring his financial transactions, which might have allowed the forgery to happen. The court also looked into BMO's duty to disclose information. It concluded that the bank was not obligated to inform Ms. Duguid about her husband's business's financial issues, as it was her responsibility to do her own research. Lastly, the court evaluated the importance of independent legal advice. While it is generally wise to seek such counsel, not having it does not automatically invalidate a guarantee, especially if the person involved is knowledgeable and acts voluntarily. Overall, the case revolved around issues of forgery, negligence, and the responsibilities of both the bank and Duguid in the context of contractual obligations and banking security laws. Now, my friend Jashan will hold this case.
The holding is what the court ultimately decides to do about the key legal issues that the case presents. It establishes if BMO committed any wrongdoing in its dealing with the Duguid, and if Duguid is entitled to compensation, how does the court decide the holding? Before making a ruling, the judge looks at some critical factors. First, the fact of the case, and second, the legal issues. Third, arguments from both sides, and the last one is past cases, precedents, and the possible outcomes in BMO versus Duguid case. First, enforceability of the Guarantee Bank of Montreal wins. The court upholds the guarantee, finding no undue influence or failure to disclose material facts. Ms. Duguid is held liable for her husband's business debt as a guarantor. BMO can proceed with enforcement actions, including assets seizure if necessary. Second, undue influence established. Duguid wins. The court determines that Mrs. Duguid was corrected into signing the guarantee under undue influence from her husband. The guarantee is deemed unforeseeable and BMO cannot collect the debt from Mrs. Duguid. Third, duty to disclose breached. Duguid wins. The court finds that BMO had a duty to disclose key financial risk about the business. Since BMO failed to inform Mrs. Duguid, the guarantee is ruled invalid due to misrepresentation or non-disclosure. The fourth one, partial relief for Duguid. Compromise outcome. The court modifies the enforcement terms such as reducing the liability amount or allowing structured payments. BMO still has a valid claim, but with certain restrictions. Now, my team member Mandeep explain further more about this case.
Hi there, now I'm going to talk about the rationale of this case undue influence and independent decision making. One of the primary legal arguments in the case was whether Mrs. Dude was coerced into signing the guarantee due to her relationship with her husband. Courts typically recognize a preassumption of undue influence in a certain relationships, whether one party holds significant power over the other, such as lawyer-client or parent-child relationships. Duty of disclosure and bank responsibilities. Mrs. Dude also argued that BMO should have disclosed more details about her husband's business financial conditions before she signed the guarantee. The court, however, reaffirmed the principle that banks do not have a general duty to disclose financial risk to a guarantor. Independent legal advice and enforceability. Another key issue was whether Mrs. Dude should have received independent legal advice before signing the guarantee. While court often encourage parties entering financial arguments to seek legal counsel, the lack of independent legal advice does not automatically invalidate a contract. Consent was implied. The court found that there was an implied consent between BMO and Duguid based on their exciting business relationship. Duguid was a customer of BMO, which meant which meant BMO could send transactional or informational messages related to his account or the services he was using. In this case, the emails were found to be a part of relationship rather than rather than unsolicited promotional messages. Exciting business relationship. The court emphasized that CASL allows businesses to send messages to individuals with whom they have ongoing business relationship as long as the content is relevant to the relationship. Since Duguid had a business relationship with BMO as a bank, now my partner Manroj will describe the another part.
My name is Munro Singh. Today I'm going to explain some question and answers. The first one was, what was the central issue in banking of Montreal versus Duguid 2000? The answer for this question is, the central issue was where Bank of Montreal breached its contractual and fiduciary duties in handling Duguid's account, leading to financial harm, as we know that. The another one is, what were the main legal principles involved in this case? The answer is, the case involved principle of contractual obligation, negligence, and fiduciary duty in the context of banking practice and customer relations. The third one was, what was Duguid claim against the Bank of Montreal? The answer for this question is, Duguid claimed BMO wrongfully handled his account, causing unauthorized withdrawal and financial damage, violation their contractual and legal duties. How did the court address the issue of negligence in this case? The court ruled that the PMO did not breach its duty of care as Duguid failed to provide sufficient evidence of negligence on wrongdoing by the bank. What did the court condone about the Bank of Montreal handling of Duguid account? The court condones that BMO acted within its contractual right and did not breach any bank obligation toward debtors that dismissed the claim. On the second page, the first one question was, did the court find that the Bank of Montreal had the fiduciary duty toward debtors? The answer is, the court found that while BMO had some fiduciary responsibility, it did not breach this duty in its deal with debtors. And the next question is, what role did the contractual agreement between Duguid and the Bank of Montreal play in the court decision? The answer is, the court relied on the contractual term between Duguid and BMO, conducting that the bank action was consistent with the agreed upon term and not a breach. The last second question is, what impact did the case have on the banking practice in Canada? The case reinforced the importance of the clear contract and paper documentation in banking, emphasizes document production while upholding legal standard for banking practice. The last and least question is, what lesson can business and consumer take from this case? As we know that business should ensure transparent contract while consumer need to understand their agreement and provide strong evidence when making claim.
So this is a presentation on Bank of Montreal versus Duguid case. Thank you and have a nice day.